You're watching FJTN, the Federal Judicial Television Network. Coming up on Court to Court.
You're here for jury selection today in a civil case. Your judge will be Norman Mordew. He expects this trial to last approximately 4 to 5 days.
We help them feel a little bit better about why they're there and what they're doing. And so when they come to the courtroom, they're more receptive. They're a little bit more relaxed.
I've been in a court now for 3 years, where every document is instantly available 24 hours a day, 7 days a week, anywhere in the world to anyone.
This is Court to Court, your connection to what's happening in the federal courts around the country, providing information and ideas that will enhance your job and how the courts function. Now with today's program, Michael Burney.
Welcome to Court to Court. Today's program features stories from the 19th century right into the future. We'll learn about the federal court trial of an icon of American history, and we'll get a better understanding of what unlimited access of electronic case files means in the courts. We'll also see 2 different courts in action as they summon potential jurors. Juries play a vital role in our judicial process, and for district court clerks' offices, the identification and selection of potential jurors commands careful attention. But at the 2 courts we're about to see, that's only the beginning.
In the geographically large Northern District of New York, some jurors must travel long distances to serve. In the Syracuse Division, jury administrator Carrie LaCourse has 2 priorities.
The first and foremost important thing would be maintaining the integrity of our jury wheel.
Court, all rise.
The other thing would be keeping jurors happy.
New York is now in session. The Honorable Norman A. Mordew presiding.
Happy juror is a good juror, and a good juror gives you a good decision. They're more at ease, they pay attention, they're interested, they know they have an important role to play. There is no other system in the world that involves its citizens as much in the administration of justice as our jury system. Without the juries, we would not be able to operate.
In addition, many in the courts believe that jury service is where the public has the most direct interaction with its government.
And we work very closely with the judge to make sure that we're utilizing the jurors properly, that we're making this a good experience for them, that we demystify what jury service is all about.
David Williams of the Administrative Office agrees.
A key result of effective jury utilization is not only are jurors utilized more efficiently, but it minimizes their disruption, and I think it increases the public perception of our federal courts.
The Northern District of New York was the first federal district court to implement the new jury management system software.
JMS has been great for us. That's one of the reasons that we were able to cut our terms down to 1 month. Because of the automation with JMS, fewer people are required to do the amount of work.
The district uses a 2-step process, sending out qualification questionnaires first.
We get back hundreds each day, and the scanning device actually separates them into 3 different bins as far as being who's qualified, who's not qualified, and anything that is unreadable by our scanner.
That time that's freed up in our jury administration office allows us to focus on other aspects of the jury operation. We spend a lot of time on the customer service issues.
And how far away are you from the courthouse?
Customer service begins by providing as much information as possible in as many formats as possible.
Please listen carefully to the entire message for instructions pertaining to your jury service.
By using a 2-step system, we're able to, with our summons, send some very important information along with the summons. We do it in the form of a newsletter.
The newsletter, a separate one for each division, includes information not only about jury service, but also logistical help such as directions and parking. The information is also on the court's website. And, of course, the jury line lets the potential jurors contact the clerk's office.
And we desperately need to talk with a live human being because we have problems and would like to ask what steps we must take.
Most of the calls involve some scheduling conflict that they have between their anticipated date of appearing for a trial. They sometimes forgot that they need to be telling us in advance of their requested dates off.
Okay, your date's in here, so you're all set. If we do have something that comes up, we'll just skip you. Let me just give you some paperwork here. And then once they get here, we just try to, show them that we're real people and that we're interested in their concerns and answering questions.
I have this excuse as of a certain date. Did I mention that to you? Or
Did you, is it a new one? Something you haven't given to me previously?
No, it's the one I mentioned over the phone where I've
let's see
written
if I've
about
already have it
being
on
out of
here.
the country.
I've got 5/8 to 5/12 and then 5/31 to the end of your term. Okay, yeah, you're all set.
In the old days, before the automated system, jurors would line up, and it would take probably 45 minutes to an hour to check in a large jury. Today, using the automated system and the barcodes, we scan their barcodes in, capture all the jury information, and can get them into the orientation room very quickly.
You're here for jury selection today in a civil case. Your judge will be Norman Mordew. He expects this trial to last approximately 4 to 5 days, so you should be out of here by the end of the week or the beginning of next week. Court hours are normally from 8 to 5, 8:30 to 5. Occasionally the judge will alter that depending on his schedule. Sometimes he may want to start later or let you go a little bit earlier in the day, but he'll let you know what that schedule is going to be when you get down into the courtroom.
Sometimes overlooked, but almost always useful to help folks feel welcome, is food. And according to the AO's David Williams, the congressional appropriation for funding juries
allows us to provide light refreshments for jurors. Coffee, tea, donuts, bagel, not meals, but light refreshments. And this applies not only whether they are reporting for jury selection, but even on the days in which they're selected for trial.
In the Northern District of New York, we have a local rule which prohibits attorneys from talking to jurors during the course of a trial. And if you don't have your juror badge on, they may not recognize you as a juror and could get into a lot of trouble. So please keep those on when you're in the building. The second reason for that is because security is really tight in the federal building.
I mean, for somebody who hasn't been called for a federal jury before, it was like I come here every day. The way the instructions were very clear.
You want to make them feel comfortable. You want to make them feel at ease. You want to make them feel like they have a role and a part, that they are not being treated as just people who are being processed through the program, but they are in fact the judges, and that the clerk's office works for them, helps them in their duties that they need to perform as jurors.
Is there anybody sitting there who feels you have been a victim of discrimination either because of your sex, your race, or your religion in the workforce, or brought an action against anybody for having discriminated against you?
To qualify a jury, the Northern District uses the strike method, in which everyone is questioned.
So when that juror leaves the courthouse at the end of the day, even if they didn't get selected for that case, they feel like they were part of the system. They feel like it worked, like their day was well spent, and the taxpayer dollars were well spent.
Mrs. Tucker, is there anything else you think that I should ask of you that would bear upon your ability to be a fair and impartial juror?
No.
Okay. All right. Mr. David Webb?
Yes, sir.
Your sheet indicates you're with Crucible Specialty Metals. How long have you been there, sir?
27 years.
Indicates you're a steel worker. Could you tell me something about the nature of that type of work?
Well, we make various grades of specialty steels. Tool steel, high-speed steels, stainless steels.
But you're in there where they actually melt the ores down?
Yes, sir.
Okay.
We get a lot of feedback from jurors. When they check in and voir dire day, we hand them an exit questionnaire, and we ask them to tell us all the good things that they experience as well as the bad things. You know, what was your feeling when you received your jury summons? How did you feel about jury service? And then after having served, how do you now feel?
That was very pleasant overall. I thought it was a very good experience.
I meet with the jury judge once a month to discuss those comments, and we distribute copies of those questionnaires to the judicial staff so everybody's aware of the things that the jurors are thinking and the different concerns that they have.
They treat you like an individual, not like just another body that we got to have to fill a chair.
They are the real judges, and that's why it's important to make them feel that way, make them feel comfortable with the system, with the court, in their job here, their duties here.
When we come back, we'll see how another district court welcomes its jury panels.
You're not going to be intimidated too long in the courtroom, because once you get in there, you figure out that you guys are the stars of the show, and y'all call all the shots.
Still ahead on Court to Court, we'll see how respect makes a difference in jury administration. We'll get a glimpse into the federal trial of a famous citizen, and we'll hear opposing views about access of court records in the electronic age. But first, watch this.
I'm an evaluation form. You've surely seen me before. Well, I'm part of your materials and I perform a vital chore. Well, the information in me helps the center to take stock. It helps them make their programs work to help you do your job. Please fill me in. Please fill me in. Oh, we need this information. Please fill me in. Please fill me in. Oh, we need to know the score. Please fill me in. Please fill me in. Your feedback is important. And if you don't complete this form, we'll sing this song again.
Your feedback is important. Please fill in the evaluation form available in your program materials or online on the DCN.
Just as we saw the Northern District of New York make prospective jurors feel welcome, so too judges and clerk's office staff in the Middle District of Florida work as a team, trying to ensure that jurors are attentive with good attitudes about jury service.
Penny Abernathy, jury administrator for the Jacksonville Division of Florida's Middle District, deals with many needs of prospective jurors, even helping those lost on the way to the courthouse.
Turn around on Hogan and go back up Hogan, away from Water Street, okay? A good jury administrator has a balancing act to perform. While they're preserving the integrity of the jury selection process and meeting the needs of the court, they must also be aware and meet the needs of the prospective jurors and jurors.
District Court Judge Harvey Schlesinger feels strongly about the care of jurors.
They're going to be the decision makers with respect to disputed facts, so you want to make sure that they're comfortable and they are attentive during the jury selection and during the actual trial process.
So we could accommodate almost anyone's circumstance. And if you write us a letter in advance and you let us know that you have this training seminar at the end of the month, or you're going to that cruise to Europe that you always want to go on, then we'll work around your schedule. If we know in advance that it's a problem, we're happy to do that.
We try to be very reasonable with excuses, so when they do come in, they can have an open mind and not be concerned about, well, am I going to miss an appointment? Did I miss a sales meeting, or am I going to not make a commission today? And they can be more attentive to what is going on in the case itself.
I think it's really important that they have a positive experience because we serve them, and this is their government in action, and this is their way to be a part of it. Making it a positive experience for the jurors is very simple. You treat them with courtesy, you treat them with respect. You're going to be asked some questions by the court. Our judges routinely have the jurors simply stand up in place and go right down the list. So please read this over and be prepared to give responses in the courtroom to the questions on here. If you would like to make some notes on this form, please feel free to do that. It can be kind of intimidating in the courtroom, and we know that. So just make some notes if it'll help you collect your thoughts while you're in the courtroom. You commiserate with them over the hardship of serving on a jury. You try not to waste their time. I know that you're all excited about being here. Right, huh? It can be inconvenient to have to call a lot during your month service. I know, it's a lot more than just a little inconvenient, isn't it?
Jury service, as I tell the jurors during their selection, usually doesn't always come at a convenient time. People have other plans, they work, they'd rather be at home, and if you can make them understand how important it is for them to participate and make it as comfortable as possible so they don't feel like they're just down here as a number, but they are a human being, they feel a lot better.
For Abernathy, gentle humor goes a long way toward making jurors feel at ease, especially when responding to requests to be excused.
That one didn't fly. You could try another one, though. Yes, sir. You're pregnant? You know, Risa, make a note of this. We have a troublemaker in the crowd, okay? You treat him like you would like to be treated if you went into a government office.
Clerk of Court Cheryl Loesch who travels often to the district's divisional offices, knows that an effective utilization rate is good for jurors as well as the court.
We use staggered starting times and multiple voir dires, and we also work closely with the judges in their calendaring to coordinate all this, so it makes the best use of the judge's time as well as the jurors' time.
But it's not always easy to put such practices into place.
Oftentimes, there's not always agreement. Sometimes it's a touchy area.
And that's difficult because I don't think anybody was willing to just voluntarily give up their right to pick these jurors when they wanted to.
Judge Henry L. Adams, Jr. is the district's jury judge. That judge designated to deal directly with the clerk's office and the other judges about any issues concerning juries.
And we rely heavily on these jury judges to kind of make that call for us. And the other judges are receptive when that jury judge is involved.
Well, then we'll have 2 fast ones and 1 slow one here, okay?
That should work well.
I think it works just fine.
Now you got to convince the slow one to be the last one.
That's your job, Judge.
Thanks, Benny.
To increase jury utilization efficiency takes a commitment from the entire court, from the judges, the staff, and the clerk's office. But I think also a key thing to understand is that you don't have to make these sweeping changes to your practices that would impact your caseload. You can take it one step at a time.
One of the issues right now we're grappling with is the use of allowing laptops into the jury assembly room.
People want their cell phones, they want their laptops, they want all that.
I think the issue is about to resolve itself because the security committee is about to back off from prohibiting laptops into the building.
The district has just begun using JMS, the Jury Management System software.
I have one piece of advice. Learn the program, inside and out.
Talk to other courts that have implemented the system already. Hear their tales, what they learned from the experience, why reinvent the wheel. And also, I think a big key is communicating candidly with your own judges. So they know what to expect, what changes they might see in the selection process so that they're fully informed.
Emphasizing the importance of the jury continues in Judge Schlesinger's courtroom. Prior to jury selection, he reminds jurors that they are part of a vital institution in our nation's history.
And that precious right was carried to the United States and in 1791 enshrined in the 6th Amendment to our Constitution, which provides in part, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury.
The judge concludes by reminding the jurors of the rule of law in the United States.
So in this great country of ours, rather than having some governmental officials such as myself, you will be called upon to resolve the disputed issues of fact in this case. And my point in telling you all of this simply is that while you are here, you're going to experience one of the highest rights and honors of citizenship and also the privilege and heavy responsibility of being a member of a jury. And I hope that you will approach your service with that attitude and in that spirit.
Whenever the district asks jurors for feedback about their experience, Judge Schlesinger says that the jury clerks are a frequent topic.
They have said that they wish the world, particularly in other governmental agencies, had employees similar to the ones that we have because they made it a very pleasant and enjoyable experience.
And the instruction on what we needed to do was real good. It didn't leave too much to question on how long or what or where or anything like that. It was really good.
And if they leave with a positive attitude that they had a good experience, an interesting experience, and tell their relatives, friends, and neighbors that, then we won't have problems with people not showing up for jury service or not doing the job that they should be doing when they do sit as a juror.
Today we have a different feature on our program, one which reminds us that issues with national significance often are woven into the rich history of the federal courts. With the story of women's suffrage on trial, here's my colleague, Bob Fagan.
In the long journey toward women gaining the right to vote, the Northern District of New York was the stage for a dramatic confrontation between the law and suffrage advocate Susan B. Anthony. an important figure in the abolitionist and temperance movements, and the most respected woman suffragist of the time, Anthony led a group of 15 women to the polls in Rochester and voted in the election of 1872. All the women were arrested and indicted, but United States Attorney Richard Crowley brought only Anthony into federal court. Ironically, it was federal court rather than state court, since states determine the qualifications of voters. But a recent federal law had been enacted which provided criminal penalties for anyone who voted in a congressional election if they were not qualified. The indictment alleged that she had cast her ballot
without having a lawful right to vote in said election district, the said Susan B. Anthony being then and there a person of the female sex.
The trial was held in the Canandaigua Courthouse, a building still used today. At the time, the town was part of the Northern District of New York, but became part of the Western District when it was created in 1900. Closely followed by the press, the trial was over almost before it began. The presiding judge, Ward Hunt, was a justice of the Supreme Court who was riding circuit. He opposed women's suffrage and removed the case from the jury and convicted Anthony of violating the voting laws. He ordered her to pay a fine of $100. To that, Anthony replied,
"May it please your honor, I will never pay $1 of your unjust penalty."
And she didn't, nor was she jailed for not paying the fine. Justice Hunt didn't want to give her any cause to appeal and carry the case further in the federal courts. It remains unpaid to this day. And the opinion of the current U.S. Attorney, Daniel French?
Well, when I took office, a couple members of my staff came to me and brought this to my attention and asked if I wanted to do anything about it, and I indicated it probably was one of those matters we'd leave for the next United States Attorney to address.
Susan B. Anthony continued to campaign vigorously for women's suffrage, but it was almost 50 more years before the 19th Amendment to the Constitution gave women the right to vote in 1920. That's a moment in court history.
Until recently, pleadings and other documents in federal court cases have been available only in paper form and from the courthouse where the case is filed. This gave these public records what has usually been called practical obscurity. But new technology in the many courts using imaging and electronic case filing means the end of practical obscurity. Now these records are available to anyone with a computer and modem anywhere in the world, at any time, day or night. Such unfettered access can cause problems. Some information, such as Social Security numbers or bank account or credit card numbers, can be accessed and used by thieves in what has come to be known as identity theft. Unlimited electronic access may raise problems in other areas too, such as law enforcement, physical security of cooperating defendants or victims, trade secrets of companies in commercial litigation, and preventing jurors from seeing the contents of pleadings during trials and deliberation. Recognizing the many implications of such instant and worldwide access, the Judicial Conference's Court Administration and Case Management Committee formed a subcommittee on privacy and public access to examine whether these new technologies might require new policies addressing both access and privacy implications. To help us understand the issues and some of the options involved in the subcommittee's work, we invited 3 bankruptcy court judges to speak with us. Chief Judge J. Rich Leonard of the Eastern District of North Carolina, a member of the Court Administration and Case Management Committee, Chief Judge Dennis D. O'Brien of the District of Minnesota, and Judge Michael J. Kaplan of the Western District of New York. They spoke with our producer, David Colm.
Judge Leonard, let's start with what types of cases raise the most urgent questions about privacy in court records?
Well, to the extent that I have concerns now, they primarily arise from our consumer cases. We require a great deal of personal information, what's come to be known as personal identifiers in these days of identity theft lingo. Social Security numbers, addresses, account numbers, bank accounts, property descriptions that, if they fall into the wrong hands, could cause actual harm to one of our litigants. And you also have people, because of their individual statuses in our cases, who need more privacy protection than others. The ex-spouse who is trying to keep her identity secret from an abusing ex-husband is an example often used, or
someone with a chronic disease who doesn't want their employer to necessarily know that they have this problem, but if he saw the list of medical creditors, would instantly know it.
Judge O'Brien, what do you think are the one or two most important concerns about privacy in court records?
I think it's important that we understand that and acknowledge that once case file information becomes part of the public record, it is no longer personal information and is no longer private property. It is a public resource. It's inappropriate, it's unfairly discriminatory, and I believe it's counterproductive to the missions of the court, and I believe in the end it would be ill-received by the public to continue to maintain and label information and records as public records, and then for the courts to begin prescribing and controlling and limiting and determining what parts of the public record ought to be disseminated generally and what ought to be withheld and disseminated to a select group of people.
How about you, Judge Kaplan? What do you think are the one or two most important concerns about this?
In my view, it ought to be addressed in legislation. The fact that courts are being permitted at this time to adopt their own policy guidelines and their own philosophies about the issue that Judge O'Brien has addressed is, to me, a matter of the greatest concern. More and more people find that people who never did anything wrong to anyone find that their names and information about their lives are being dragged into federal court cases. I don't think that government should be in the business, but courts in particular, should be in the business of being part of that problem by broadcasting or publishing this information. We do not necessarily need to have the names and social security numbers and addresses of the various people who are involved in the case.
If the concern is social security numbers, names, and addresses, then the question that I think ought to be asked, discussed, addressed, and determined is, should names, addresses, social security numbers be part of the public record? Not, should this part of the public record be available here but not there?
But do you agree that we could remove or mask a number of the public identifiers that we require now without doing any great harm to the integrity of the process or the information that the participants need in order to participate in the case?
It would be extremely difficult technologically, but also very time-consuming to go in and extract the information wherever it might be found in those environments that are not structured data environments.
But assuming that identifiers such as social security numbers, addresses, have to be part of a file, shouldn't Congress be stepping back and saying, let's regulate that use the way we regulate the use of credit information under the Fair Credit Reporting Act?
Judge Leonard, how do you see this issue? What's more important, privacy or access?
Well, I think it's a bit of a red herring to set one up on one side and one on the other as if the two can never be reconciled, because I think what we're trying to do is reconcile the two. I think we have to figure out ways to protect those sensitive personal data that can be taken, purloined, and used. Past that, I wouldn't be so concerned.
It seems to me that we have to recognize that almost anything we do in this area may well have very unintentional social consequences. I'm not a scholar on those kinds of issues, but I fear that anything that we do that chills the willingness of people to be named as a party in interest in a federal case, someone who's done nothing wrong and maybe has done something very helpful for people, is going to have adverse social consequences.
The public will demand that the public have ready, convenient, cost-efficient access to the public record. And today, that's electronic access, and that's the internet venue, and without that, I believe that the federal court as an institution stands to become marginalized in our society.
Judge Leonard, what are the main problems and challenges for the subcommittee on privacy and public access as the subcommittee examines these issues and works to make recommendations to the Judicial Conference?
Well, I've spent approaching 25 years in the federal courts, and I've been on a lot of committees, and I've never quite seen one with as thorny a set of issues and as heartfelt opinions on all sides as this one. I mean, we have listened to all the experts we can assemble, and we are trying to be as thoughtful and careful as we can, understanding that we may not have an instant solution that satisfies everyone, but we have to take steps. Otherwise, we are going to balkanize this issue where all of the district courts, all of the appellate courts, all of the bankruptcy courts are going to have their own local rules, written or unwritten, about electronic dissemination.
So you think the likely result of this will be some nationwide policy?
I hope so.
It may not be instantly, but I do think within the next year or two there will be some nationwide policy. Implementing that, though, can be complicated, too. Some of these things can be done by federal rules that the courts, we ourselves, control. Others really do take change in congressional legislation.
Are there any other topics about privacy and public access that any of you would like to make any other comments?
Proximity to the courthouse doesn't matter anymore. The lawyer who put his office right next door and for years had a market that no one else could bother, has had that market power destroyed because the lawyer 300 miles away has the very same access to the documents, has the same access to file as the lawyer next door. It's frankly lessened lawyer control of their clients because many of our sophisticated clients now are not completely dependent on their lawyers to get all of the information filtered through them about what's going on in their case. So I think there are all sorts of good things that are coming out of this that in our haste to make sure we don't infringe on anyone's legitimate rights, we need to keep an eye on because it's an exciting new day.
I think that much of what we're seeing, much of the consternation and angst that we're seeing here is the natural process of undergoing what will prove to be a profound cultural change in the way we think, the way we do business, and in the world in which we live. This is not unique to the federal courts. I think that these things will shake out and will take care of themselves.
I think the important thing is to focus on the role of government in that process and to bear in mind that we are the people that we serve. I want my government to be concerned about protecting my interests, my rights, and to let the private sector worry about itself and to make sure that what is going on out there is fair and just and that the courts are maintained as a safe haven.
Thank you, Judge Kaplan, Judge O'Brien, Judge Leonard.
Thank you, David.
Thank you, David.
We're really grateful, extremely grateful for your participation today. You've given us a lot of good information about this difficult but also very timely topic. Thank you.
You're welcome. Thank you.
More of this discussion among these judges about public access and privacy will be shown as a separate Judicial Center program on the FJTN on December 8th and 21st, and again on January 17th and 25th. For broadcast times, check the FJTN Bulletin or the Center's DCN site. That's our program for today. We want to hear your comments about Court to Court. Contact us at the Center's DCN intranet site. The address is on the screen. Click on Court to Court, select Online Evaluation, print the form, and then fill it out. You can also tell us topics you'd like to see on future programs. Mail or fax the evaluation to us. Our fax number is 202-502-40.